Right, welcome back. And the commission, for the implementation of the Constitution's term expired in December 27th of 2015, and it is a proposal by Attorney General Gideon Muigai and Parliament that the roles that were held by CIC, those functions be transferred to the Kenya Law Review Commission. And their argument is that they already were performing these roles under the Repealed Law Reforms Commission Act, that is Chapter 3 of the Repealed Law Reforms Commission Act. So we want to find out from the Kenya Law Review Commission what exactly that would mean, what the transition to them would mean, and how they are preparing to take over these roles. They were joined by Joash Dashe, who is the CEO of the Kenya Law Review Commission. He is also going to be speaking to Mutegi Njau. We welcome your views, your comments, and your suggestions on the same. The SMS number is 22422. That number again is 22422. And of course, on Twitter, the hashtag remains Power Breakfast. Mutegi.
Welcome.
Thank you, Mutegi.
Happy New Year.
Happy New Year.
Maybe we have been here before, but let's start from the basics. Tell us what the Kenya Law Reform, not review, Kenya Law Reform Commission, what you do.
Thank you very much, Mutegi. The Kenya Law Reform Commission is a national government agency that is set up by statute, the Kenya Law Reform Commission Act of 2013, to keep under review all the law of Kenya, to ensure that the law meets societal needs, that the law comports with the Constitution, that the law obeys international obligations that Kenya is a party to. When we talk about the law of Kenya, we mean both national legislation and county government legislation. The Law Reform Commission, in a nutshell, therefore, is the link between government policy making processes and government legislative processes. We are the link. We are the link.
Law reform. Why is it that this government, this parliament, has passed many laws that have been taken to court and rejected by the court when you are there?
Absolutely. Mutegi, let me clarify something. The Kenya Law Reform Commission is one of the organs of implementation of the Constitution, together with the former CIC and the Attorney General, and of course CIOC, the Parliamentary Oversight Committee. Yes. What we do, we participate in the development of bills. And just remember, after the ministries, departments, and agencies have done with their policy framework, it is brought to the Law Reform Commission. We frame these policies into draft bills, which we then forward to the Attorney General and CIC, as it was then. CIC would then call a roundtable where the final consensus on the content of a draft bill are arrived at. That is not the end of lawmaking. From CIC, the bill is taken back to the Attorney General, who together with the Minister or the Cabinet Secretary responsible for that matter, takes the bill to the Cabinet for approval. The Cabinet is the highest policy-making organ of government. From the Cabinet, the bill is then transmitted to Parliament. Parliament of the Republic of Kenya, both the Senate and the National Assembly, are the legislative bodies in Kenya. At the county level, you have the County Assembly. That is where the final contents of a law are arrived at. Immediately Parliament enacts a law, it is taken to the President for assent. Once the President has assented, that is the law of the Republic of Kenya. The Law Reform Commission at that stage has absolutely no responsibility. And that is why we are there. We are required to relook at the law once it has become law, to ensure that it is reviewed or amended to comport with the aspirations of the people and the Constitution. And therefore, that's why you have the judiciary.
When the Commission for the Implementation of the Constitution was there, if the law that was passed by amendments or were made to draft, like the security laws, which were not in conformity with the Constitution, the Commission for Implementation of the Constitution would go to court and challenge that and many other interested parties. Now that they are not there, can you do that yourselves?
Absolutely. There is no doubt that the Law Reform Commission is capable of doing that.
But have you ever done it?
We have been doing this for the last 30 years, except, Mutegi, we have not gone to court as an institution.
Suppose the law...
It does not mean we are not consulted. By the way, we advise the executive. We advise the Attorney General. We advise county governments. We advise Parliament. By the way, even private members' bills are run by the Law Reform Commission, so that we give our comments. The fact that we do not go to court, we do not shout, we do not call press conferences and shout, does not mean that we don't do the work. There is absolutely no vacuum. However, remember the architecture of our constitution. We have constitutional commissions and independent offices. CIC was just one of them. One of the generic and principal functions of constitutional commissions is to promote constitutionalism, to provide oversight, to ensure democratic governance processes. And Article 48. You have the judiciary as the arbiter in case of conflict. You have a very vibrant media and free media in Kenya, a very vibrant civil society. So in terms of oversight, you have a very informed citizenry. There is absolutely no vacuum. No doubt about it. CIC did fantastic work. The framers of the Constitution,
not according to Duale.
The framers of the Constitution knew that if you left implementation of the Constitution to the executive, for example, only, to Parliament, for example, only, or to the judiciary, for example, only, then you would not implement the Constitution. And therefore CIC was established by the framers of the Constitution as a transitional mechanism during the first 5 years of implementation of the Constitution, to ensure that all the bills that are done pursuant to the provisions of the 5th schedule comport with the Constitution. And the framers of the Constitution themselves determined 2 instances when the term of CIC would come to an end: 5 years upon its establishment, or upon full implementation of the Constitution, as determined by Parliament, whichever is sooner.
Now,
the 5-year period.
The 5-year period
has expired.
Expired.
Yes.
Not all the bills, the laws have been passed. The Law Reform Commission is seen as part of the executive, is part of the Attorney General. So there is mistrust that you will be able to implement whatever is left but not achieved because of the expiry of the CIC. So some lawyers, including the Law Society and some eminent lawyers like Muite, are arguing you shouldn't get that responsibility because you will not be able to. You are part of the executive. What do you say? What do you talk?
Let me disabuse this notion that the Kenya Law Reform Commission is not an independent entity. You remember, first we draw our authority from the Constitution itself, just like CIC did, the 6th schedule to the Constitution. 2, we have been doing this for the last 30 years. In fact, one of the critical periods in the history of Kenya was after the 2007-2008 post-election violence, when no one trusted any institution of the state. We worked in the background with the Kofi Annan team to prepare amendments to the Constitution that gave rise to the Agenda 4 commissions. At that time, no one was questioning the independence of the Law Reform Commission. Yet we did this. We even did the law that gave rise to CIC itself. We drafted the law which operationalized all constitutional commissions, even the Interim Independent Electoral Commission. We did all this, the Truth and Justice and Reconciliation Commission, the National Accord and Reconciliation Commission, the National Cohesion and Integration Commission. We did all this in 2008. Bringing forward, immediately the Constitution was promulgated. The Kenya Law Reform Commission was identified in the Constitution itself as one of the organs of implementation of the Constitution. This has since been re-emphasized in the 2013 Act by Parliament. Parliament designed the structure, the mandate of the Kenya Law Reform Commission to undertake all these responsibilities in Section 6. Now, talking about our independence as an institution, that we are part of the executive, I want to dispel that rumor. I want to dispel that notion. One, our commissioners, the chairperson is appointed by the president. Two full-time commissioners are appointed by the cabinet secretary after a competitive recruitment process chaired by an independent selection panel where the Law Society of Kenya, for example, is represented. This is the manner in which all other constitutional commissions and independent offices, the holders, are appointed. So in that sense, we are independent.
No.
In terms of...
The argument is that you are not independent because you are answerable to the Attorney General.
We are not answerable to the Attorney General. In fact, our act mentions specifically the Kenya Law Reform Commission is independent. I'm head of the Secretariat. I'm a lawyer. All the lawyers that work under me are all professionals. We exercise what we call, when we are reviewing bills or we are drafting legislation, we exercise what we call professional or intellectual independence. We give our advice without fear or favor. The third point I want to make about this independence, so that we get this off the minds of the people of Kenya, is that independence does not mean lack of accountability. As a public institution, we are still accountable to the people of Kenya and to Parliament. We are still subject to the same procurement regulations. We are subject to the same public finance or management regulations.
Clarify this.
We are subject.
What is the relationship between the Commission and the Attorney General?
The relationship between the Commission and the Attorney General is that the Attorney General is the policy minister, is their policy cabinet secretary. Like all constitutional commissions and independent offices, there must be a policy head who sits in the cabinet. None of the constitutional commissions or the chairperson of IBC does not sit in the cabinet. The policy issues of IBC are channeled to the cabinet through the responsible cabinet secretary. In our context, currently, it is the Attorney General. So that question of lack of independence does not arise.
How many bills are yet to be implemented?
About 12, with regard to the implementation of the Constitution.
Given 1 year.
And Parliament, in his own wisdom, decided to extend the period.
In his own failures.
In his own wisdom, decided to extend the period of 1 year. But remember, they are allowed to do that. They are allowed to do that under the Constitution. The same Constitution that we are defending allows Parliament to extend the period of implementation of the fifth schedule by at least one year, and they took that option.
The fear is that those 12 bills, in the absence of CIC, they may be driven by the executive.
Let me explain something. Even if CIC term was to be extended today,
yes.
By the way, the Constitution says Parliament may extend the term of CIC. So that discussion, because the parliamentary CIC report has been tabled in Parliament but has not been debated, we cannot speculate on how Parliament is going to debate. But even if CIC term was to be extended today, they are not going to be seized of those bills again. Remember, those bills have been cleared by the Law Reform Commission, the Attorney General, and CIC itself, even the cabinet. Those bills are now the property of the House of Parliament. So even if CIC were to be revived today, they'll not recall back those bills to analyze. So that argument is faulty, that the bills are going to be driven by the executive. The executive has nothing to do with those bills now. The bills are already the property of Parliament of the Republic of Kenya.
So, if that is the case, then why is the Law Reform Commission asking for the budget of the CIC and the assets?
Absolutely.
Well, why do you need it? Because of your own budget, the CIC budget, the CIC is out.
Let me give you.
Why do you want
let me give you a practical example. In this financial year, 2015-2016, the Kenya Law Reform Commission budget, total budget, is 223 million. It is this 223 million that we are supposed to use to pay for our operations. At the same time, do programmatic work, serving both levels of government. This same year, CIC had a budget of almost 500 million. Interestingly, and this is the crux of the matter, CIC commissioners' salaries were paid for by the consolidated fund. So whatever money they get at CIC is used for programmatic work. The Law Reform Commission, the 223 million that I have got, I use this to pay even commissioners' salaries. In order to cement the independence that we are enjoying, we need financial autonomy. We need financial independence. This can be achieved by two ways.
What are you saying? That you are not independent anymore?
No, we are independent, except we need financial autonomy. Let me explain. Financial independence will be achieved in two ways. One, we need a separate vote of the Kenya Law Reform Commission. This is a decision which can be made by the National Treasury, and we're engaging them. We have already spoken to the Treasury. We are speaking to the Auditor General and the Solicitor General and the Attorney General, so that we get an independent vote. Two, let the Law Reform Commissioner salaries be paid from the consolidated fund. Three, let us be given additional resources so that we're able to undertake this massive responsibility. Remember, we're also assisting county governments in the preparation of their legislation. And county governments are 47. Each of them have their own county assembly. Each of them make their own law. They're all right to the Law Reform Commission. In fact, on a daily basis, Mutegi, I live here, I go to my office, I find over 10 bills submitted to me by the county government to review for them. I have 2 dedicated professional staff only. Imagine if I had 10 dedicated professional staff to do this work. I mean, we are up to the task.
If somebody is asking the same question, yes. I was saying, the Law Reform Commission is a government agency. How will they challenge the bad laws that emanate from the executive? You have never heard of them before?
Mutegi, that's a misnomer. We've been there. I've just explained that we have been there, and the fact that we are not part of the executive. We are an independent statutory body. I've explained that all constitutional commissions and even independent offices are all part of government. So the issue of being not part of the government does not arise. That's why they drive GK vehicles. They are subject to the same public audit that we are subject to. So the question of independence does not arise. It is true that we don't shout at the rooftops, but this is the beginning. In fact, this is not the first time I'm coming to this studio.
Do you have a message going to court if Parliament ever passes a law that is unconstitutional?
That's the right of every person, the right of every citizen.
Do you have the mandate? Can you do that?
Absolutely. Under our Act, Section 5 of the Law Reform Commission Act, the Law Reform Commission can sue and be sued in his own name. So nothing.
Then how come you've never sued? How come? Say, for instance, the latest miscellaneous bill that requires that the Judicial Service Commission, according to Parliament, this amendment was done on the floor of the House. They decided to include the fact that the Judicial Service Commission will give 3 names to the President to appoint 1. And they are saying no. The Constitution says they will recommend 1 person, not 3.
There are 3 points. 1, the matter is already in court, and therefore it is sub judice. I'm a lawyer, professional lawyer. I respect the rule of law.
Yes.
And therefore I cannot comment on the merits of the case before court. But having said that, for purposes of this debate, our Constitution, through the statute law, through the Revision of Laws Act, Chapter 1, as a very useful tool. That tool is used by the Attorney General every year to amend many pieces of legislation. That is the Statute Law Miscellaneous Amendment Bill. It is a very, very useful tool. The idea is Statute Law Miscellaneous Amendment Bills are supposed to be used to make minor alterations to the law, to ensure that we remove absurdities, that the statute book is harmonized, to remove editorial mistakes, etc. in the law. That is the province of Statute Law Miscellaneous Amendment Bill. The second point I want to make is this. There is nothing as critical and as important to a modern democratic society like Kenya than high-quality legislation. The process of making the law is as critical as the law itself. When a large section of the population, parliamentarians themselves, policymakers, constitutional implementation organs, are questioning the process of making the law, then I think we need to step back and ask ourselves, did we do this rightly? That process, remember, the Constitution demands public participation in the process. This simply means that even with regard to statute law miscellaneous amendment bills, there must be sufficient notice. It must be published in advance so that the people of Kenya are able to contribute this. If the process followed is constitutional, then let the judiciary, which is very independent, interpret that law and tell us, in this law, I think a mistake was made here. We go back to the drawing boards.
You have seen there is a feeling that this country is going backwards. In fact, there was a survey showing that the country is going back to old kind of times in terms of implementation law, in terms of many things the government is doing. Like, for instance, the appointment of the Chief Justice, or the appointment of the police inspector,
Yes.
or the deputies. The Constitution makes us plan that we don't have an imperial president. The president comes and says, oh, you know, I cannot do anything because my arms are held. So, what is your view about that?
Mutegi, let me state categorically that Kenya is not going backwards, but we must be internally vigilant. That's why I praise the press. We have a free press for lighting, for bringing all these issues forward. We have very informed citizenry, which then brings these issues forward. We have a very vibrant civil society, which then bring these issues forward. But we were too ambitious. This is where I think we need clarification. We were too ambitious. We were saying that a constitution which has been there for 50 years, we want to implement it within 5 years. No one has ever done this. In fact, as a country, we've done so well, but we are very self-critical. And that's why I think we need to disabuse the minds of the people of Kenya. Kenya is not going backward, but it is important for these matters to be raised by a free press. We must be eternally vigilant. And therefore, what is there in the press, what is there in the media is very useful. But I don't think Kenya is going back.
But there are serious efforts to muzzle the press. There are serious efforts to muzzle the civil society. You remember when they wanted to pass a bill that they can only get 15% from outside.
And the wish was blown, and the matter shelved, which means if the press is not vigilant, then some of these things will happen. My point is this: it is important to keep on the pressure. It is important to be alive. It is important to be awake to these things. But Kenya is not going backwards. In fact, the Kenya of 2013, 4th of March, is so different from the Kenya of 11th of January 2016. In less than 3 years, we've made fundamental progress.
The regulations are being passed about controlling the media, that you cannot advertise, for instance, more than 14 minutes in an hour. You cannot be an anchor or an announcer and do advertisement. Those policies are supposed to be determined by the media houses are now being determined by people outside.
These are draft regulations. In fact, if they are brought to the Law Reform Commission, as they ought to be under the Statutory Instruments Act and the Attorney General, we'll look at them and we'll provide our advisory. These are draft regulations which have not yet been implemented.
So if you are going to be in charge of the 12 bills that are left to be implemented for the next 1 year, and if the Treasury and whoever is supposed to give you money doesn't, what will happen?
We've been doing this all this time.
But we are saying we are not independent because we need financial independence.
We have been doing this all this time. We are just saying that in order for us to escalate, in order for us to have our presence felt nationally, we need additional resources. But we're not saying that we're not capable. In fact, through our development partners, we've been able to attract donor funding. That's how come we are doing programmatic work. We have a lot of support out there from donors. But you're saying it is not sufficient. We need additional resources. And once again, let me reiterate this. There is no law required to implement the Constitution. The last 5 years, that has not undergone a rigorous process of review by the Law Reform Commission, together with the other organs of implementation of the Constitution. When decisions are finally made on the floor of the House, we have no role to play there. Now, that is why you have the courts to resolve these disputes. But you see, the other thing that we've done, and I'm glad that I've been given this forum, we have taken a massive, comprehensive audit of all the laws that we enacted from 27th of August 2010 to date, just to check if these laws have worked. That report is there. It is on our website. We are currently going to implement that report through proposing appropriate amendments. It means we are doing some work. Remember, all the laws that we passed in the last 5 years were not anchored on any policy framework, because the Constitution demanded that they must be done within specific timelines. We are saying these laws have served us, but not so well. We need to have them changed. As Law Reform Commission, we took that initiative. No one told us. And we've done a comprehensive audit. That audit report is on our website. It is in the public domain, and we are going to implement it.
Are you effective?
We are effective. The Law Reform Commission, every day...
Somebody says, yeah, it's never out of you.
The Law Reform Commission, for example, every day I receive hundreds, tens of applications for potential lawyers, interns and pupils who want to come and do their pupillage at the Law Reform Commission. It means you are doing something. It means you are doing something right. By the way, being a generalist body, we draft, review all manner of law. One day, today, I'm doing the climate change law. Tomorrow it will be the securities bill. The next day is the companies. There is no other institution in the entire country where you can get that sort of expertise and professionalism.
How are you going to convince people like the Law Society of Kenya or people like Mwite who are saying that we shouldn't be given that the budget and the responsibilities of the CIC?
Let me tell you, the Law Society of Kenya is one of our principal stakeholders. We speak to them. In fact, when I was very surprised when those statements were made, but of course they were made, and they were speaking they were speaking to the press. If anything, one of the members of the Law Society of Kenya is actually a commissioner at the Law Reform Commission. Work very closely together. They are one of our key stakeholders. So just watch this space. We are going to speak to Senior Counsel Mwite and the others, and we're already speaking to them, so that they give us the necessary support that we need. I've just explained what we've done in the background without the people of Kenya knowing. With CIC and these other institutions were not there, as we were there.
What is the status of our laws, particularly the old colonial ones?
The old colonial ones, this is what the Constitution says, Clause 7 of the 6th schedule to the Constitution, that all laws which were in force on 27th of August 2010 continue to exist. But they must be construed, they must be applied with the necessary modifications so as to comport with the Constitution. What have we done? We are undertaking a massive review of the statute book. We are looking at Chapter 1 to the 800th chapter of the Constitution to ensure that all the law of Kenya comply with the Constitution. We cannot do this in 5 years. We cannot do this in 1 year. The South African Law Reform Commission, remember after the 1994 Constitution, we were there about 2 years ago. The Law Reform Commission of South Africa, they have tried and they have done a third of aligning all their existing law with the Constitution. So this is something that we are doing incrementally, and we are doing it sector by sector. But eventually, we know we are going to be there. The framers of the Constitution knew that you could not change all the law overnight. That's why Section 7 of the 6th schedule to the Constitution is there.
Apart from financial challenge, what other challenges do you have?
Apart from financial, the biggest challenge that we have is that lack of sufficient resources, and obviously, you know, 2016, 2017 is going to be an election year. A number of issues may be swept under the carpet because now we are proceeding to elections, and that's why I want to urge the people of Kenya, the constitutional commissions and independent offices, we must be eternally vigilant.
There's a feeling among some people that there are quite a number of people, particularly in the executive and civil servants, who are against the implementation of the Constitution, who play lip service. They are not committed. There is no commitment into that. They would like the status quo to be.
They have not succeeded. That is why the Constitution itself created organs of implementation of the Constitution. We knew that there would be this resistance to change. The framers of the Constitution knew that there would be this resistance to change. That's why organs of implementation of the Constitution was specifically established in the Constitution. We have in our constitutional firmament, our constitutional establishment, we have oversight organs. For the first time, we have working constitutional commissions and independent offices. They are supposed to provide oversight. Let me give you an example. In the financial sector, you have the CRA doing fantastic work. In the security sector, you have the National Police Service.
You might say so.
Commission.
CRA, you might say that.
In the Judicial Service sector, you have the Judicial Service Commission.
You remember they were on board? And the CRA saga? And you are telling me they are independent?
I remember, but
they can be bypassed.
Not really. Not really. Not because the Constitution is very specific on the functions of CRA, for example. The functions of the SRC, Service Administration Commission. All these bodies were not there in the previous Constitution. Probably the debate that we need to have, are we operationalizing, are we giving these independent constitutional commissions, independent offices, the necessary tools to undertake the responsibility that the public of Kenya and Parliament has assigned them?
Why did we establish a Police Service Commission? And we changed the title from Commissioner of Police to Inspector General of Police to give him independence. But when you look at it now, you look at the Inspector General of Police, would you really seriously say he is independent the way we envisaged?
Absolutely. There's something else, Mutegi. If the people of Kenya took their time and looked at the Constitution, I want to take you to Article 259, Sub-Article 11. It says, if as a state organ, or if as a state officer or public officer, you are required to make a decision on the recommendation of, in consultation with the consent of, you cannot make that decision unless you consult this person. That is in the Constitution. That's why the President says, the President says, his hands are tied. He must consult the Judicial Service Commission. And as I said, if the process followed is participatory, there would be no problem. By the way, the Inspector General of Police or the Deputy Inspector Generals of Police are appointed by the President on recommendation of the National Police Service Commission. They cannot get, the President cannot get the Inspector General from elsewhere. It must be recommended by the National Police Service Commission after an open recruitment process. That's not true. I've looked at the Statute Law Ministers Amendment Act. It is the appointment procedure must be transparent, and the recommendations must be made by the National Police Service Commission. The only change which are made, in terms of removing these people, including cabinet secretaries. You remember, as the head of the state, the President looks after the entire country. The President must ensure that the security of the people of Kenya is guaranteed, the best public interest is looked after, health, environment, all these considerations must be made by the President. And therefore, what we are saying, if you want to appoint someone, there is an independent constitutional commission there who is going to undertake the recruitment process and give you the name. Remember, the President must still take these names to Parliament for approval. So there's a lot of control.
Dismissal?
Dismissal, you don't.
That's why the problem is.
Yes, you don't need. I don't agree that you need authorization.
A tribunal
from somewhere. There's a procedure. There's a procedure for example, members of the Police Service, National Police Service Commission. If you want to remove them, there's a procedure. There's a tribunal which must be established. That does not apply to the Inspector General of Police, who is an appointee of the National Police Service Commission. So that distinction must be drawn.
Does the Inspector General of Police have security of 10?
They are appointed for 4 years, but in terms of the same two cabinet secretaries, even the Attorney General, they don't have what you call security of tenure, as it were, because if they violate the Constitution, if they violate the law,
and the president sacked them at home.
Not really. I don't think that is possible in the present constitutional dispensation.
Isn't that what the president wants? Be able to sack them when he wants.
I wouldn't speculate on what the president wants. But it comes to interpretation of the law. I know what the law says, and the law is very clear. The president cannot appoint anyone outside those recommended by those independent commissions, and these positions are advertised, and Kenyans who qualify apply, and then the National Assembly or Parliament must approve
but the Parliament
is different from removal. If you want to remove a member of a constitutional commission, you must set up a tribunal. But if you want to remove the CEO of the Law Reform Commission, you don't have to set up a tribunal.
Anyway, the way a lot of people think, particularly the opposition and civil society, is that there is a move to return to an imperial president, that he wants those powers that were not there, that we are trying to shed from him.
After watching this debate, I'm sure they are going to change their minds. Something else that people may not know. I told you I get a lot of private members' bills. One of the funny proposals that I got was that they want to make the president or governor part of the parliament and county assemblies. We dismissed that out of hand and said what we have in our constitution, we have absolute separation of powers.
But there is a move by Parliament to amend the Constitution so that cabinet secretaries are members of Parliament.
We'll meet them.
That is a move to do.
Even that proposal was there. We rejected it. We rejected it. We rejected it. We explained to them that you cannot do that unless you amend the Constitution. And amending the Constitution, by the way, is not easy. It is 5 years down the line. Have we amended even a comma? It is not easy amending the Constitution. But if a law is passed that violates the Constitution, the courts are going to declare that law unconstitutional. And they have done this over the years.
When they were departing CIC and Mr. Charles Nyachae did recommend that the reduction of members of the County Assembly, members of the Senate, members of Parliament, members of National Assembly, the government wage bill is too high. Reduce that.
Of course, CIC made that recommendation.
Yeah. And even
ordinarily,
even Mr. Musekuri and other people.
Absolutely. Ordinarily, if as a respectable institution, if you want to retain respectability, you must make recommendations that are capable of practical implementation. As it is, these are just recommendations. When it comes to practical implementation, you require to amend the Constitution, you require to amend different pieces of legislation, and that's why we'll wait for them.
Thank you very much.
Thank you very much. Thank you very much.